Hi, everybody. For all those that got to see me kind of click around, I'm sorry I had a little bit of technical difficulties, but that all got sorted. There's another funny little technical difficulty happening is that a few of you probably got a Zoom link that has created a situation where you've logged in as Ann Pernick and you do not identify as Ann Pernick. So take a look at what it lists under your self-view and screen, and you should be able to actually edit your name on there and put whatever your name actually is, as well as your pronouns if you choose to, and any organization. But yes, welcome everybody to the space. We have a pretty meaty conversation today, and so I am going to try to get us in there as quickly as possible. But just to say, for those that are probably newer to the space, this is actually our first time we've ever experimented in Safe Cities with having a joint organizing network call with a network of elected officials call. For those of you that might not be too familiar with what Safe Cities is and what our theory of change is, we really believe that the best way to get fossil fuels out of our cities is by working both inside of City Hall and outside of City Hall. So we work with advocates externally who are trying to push local government leaders to do the right thing and pass groundbreaking policies. And we also work with folks inside of City Hall, whether that's through volunteer advisories, through staff, or elected officials themselves, to help support them in finding the best policies forward. And we actually thought that this opportunity, where there is such a big conversation happening nationally about building electrification, about the sort of legal, weird, wonky moment that we're in, that it made sense to actually co-host this and have folks from both sides of it too. So just know that you are amongst friends. Some folks that would do this work professionally, some folks that have been doing this work for volunteers for years, and we welcome both of your questions. Again, my name is Michelle Pignon. I actually run the organizing network call, and I'm just a little host, but I am actually going to spend my time handing it over to Ann Pernick, who's going to introduce the topic as well as our guest speaker. One final thing to note sort of on the technical pieces of it, if you'd like to introduce yourself, you can go do so by going to the chat and putting your name, organization, pronouns, and where you're calling in from today. Because there'll be quite a few of us, we're going to be making a lot of use of both the chat function as well as the Q&A. So if you at any point need any help finding those, feel free to direct message me or my colleague Nathan Taft will be running tech support. But without further ado, there's a lot of meaty, wonky policy stuff to cover. I'm going to hand it over to the lovely Ann Pernick, the real Ann Pernick.
Thank you, Michelle. And it's so great to be with you all today. Thank you for being here. In case you missed the note, I accidentally sent everyone my personal link for the Zoom instead of your personal link for the Zoom. So if you are identified as Ann Pernick and you're not Ann Pernick like I am, please change your name on your nameplate so we know who you are, and apologies for my mistake. Again, we're so glad to have you here. I am Ann, I'm with Safe Cities. And I'm going to take us quickly through the agenda and do some quick housekeeping and then introduce our speakers. So our speakers today are Cheryl Davila, former Berkeley City Council member and a co-sponsor of the very ordinance this case is about. We also have attorney Kara Saylor from the Green Energy Institute speaking on the background on the decision, the good and bad of where we are now, and the pathways forward for local governments on building electrification. I want to thank Cheryl and Kara and all the people at Safe Cities and our Stand colleagues and the Green Energy Institute, all of who helped make this event possible today. We are recording this event for sharing and for posting. I want to ask, we tell you that we welcome your questions, and I want to ask you to put those questions in the Q&A tab. We will see them there and answer as many as we can. Questions can get lost in the chat, so please put them in the Q&A tab. And while we are on that Q&A piece, I want to note that we're not expecting Kara to be able to answer detailed and technical questions specific to every community or jurisdiction that could be on this call right now. We hope to stay in touch with you and help support you in what your community is going to do on building electrification. And this really needs to be a continuing conversation through this whole year and beyond. We're going to welcome your questions about where you are, but just not expect that we can answer them all today. In the theme of continuing conversation, I want to note that RMI and partners are also hosting a webinar next week on the same topic that I know my team is excited to join. And so we hope that you're in that conversation too. The more we are talking about this, the better. We'll share that link for that webinar just a little bit later. If we keep talking about this decision and building electrification and acting on what we learn together, that means that we're identifying and developing and passing the solutions. If we stop talking about it today or tomorrow, or we don't act on what we learn about the many pathways forward, that means that we are wrongly believing that there are no pathways forward on building electrification. And that would mean that there's a chilling effect. And the gas industry has won over local health and safety and over global climate well beyond the Berkeley decision. We can't let that happen, and we don't need to let that happen. And that's why we're all here today. And the reason why, just in case, a very quick primer. Buildings are one of the leading sources of climate warming emissions from cities, and the health impacts of methane gas in our homes are becoming increasingly clear, including that methane gas is especially harmful to kids. Recent research shows that almost 13% of childhood asthma cases in the US are attributable to gas stoves. So with that, if Cheryl is here, yes, Cheryl's here. And I'm going to introduce Cheryl and then turn it over to her. So Cheryl Davila, former Berkeley City Council member, co-sponsor of the building electrification policy. During her time on the council, Cheryl sponsored and co-sponsored over 300 pieces of legislation to promote the health and well-being of Berkeley residents and safeguard our environment from further degradation. Cheryl is also the founder and director of the Climate Emergency Mobilization Task Force, an advocate on many issues, and an advisor to Safe Cities. Cheryl is going to take us back in time and remind us of when no city had passed a building electrification policy. Thank you for being with us, Cheryl, and take it away. Oh, I think you are still muted.
Yes. Okay, now I'm unmuted. Thank you. Thank you, Anne, and thank you for having me here today. Yes, while I was on the Berkeley City Council, I first we declared a climate emergency declaration and passed a fossil fuel free resolution, which began the whole process of the community coming together and talking about climate. And so we had a ad hoc subcommittee at the city, but then in the beginning, I think it was 2019, the mayor changed the ways we were doing things and wanted to eliminate the ad hoc subcommittee. So the community wanted to keep continuing. And so that's how the Climate Emergency Mobilization Task Force was formed, at which we were coming up with policies for cities to pass, and the electrification in new buildings or no gas in new buildings came from the CEMTF. So that's how it all got started. And we realized at that time how important it was for us to pass this legislation, because electrification is much better for our community members, with the off-gassing from gas in your houses, in your heaters, in your stoves, and all the different health impacts. So that's why we wanted to do it, and that's why we got it done. My office could have taken the lead, but I passed it to the other council colleague, because I knew that person would be able to get the information out of the planning department that probably wasn't going to be easily accessible by this Black woman, new council member. So, but we did it, and I'm so excited that so many people have since done it, and look forward to more people passing this legislation. But we also have to remember how it impacts the marginalized and low-income communities, and pay attention to those effects as well. So thank you again, Anne, for having me here. And I'm not sure I'll be able to stay the whole time, but this is an awesome event. Thank you.
Thank you so much, Cheryl. Thank you for the leadership on this issue and for sharing that with us today. And now I will introduce Kara Saylor. Kara Saylor is Director and Staff Attorney for the Green Energy Institute. Kara wears many important hats and has been doing groundbreaking work well before the April Ninth Circuit decision in developing and vetting policy options for building electrification for Oregon local governments. Many of these options are available to local governments in other geographies as well, as she'll be going into. Kara also works on regulatory proceedings at the Oregon Public Utilities Commission and clerked for a dozen years at the U.S. District Court, District of Oregon. Kara will be giving the background on the decision, going into some key details on what the decision means, and identifying the many pathways forward on policies. Thank you so much, Kara, and take it away.
Thanks so much, Anne, and what a thrill to share the stage here with somebody who was so important to what I'm going to be talking about today, showing great leadership. So thanks to Safe Cities at Stand.earth for inviting me here today. As Anne said, my name is Kara Saylor. I am the director and one of 3 staff attorneys at the Green Energy Institute. For those of you who don't know GEI, and I imagine that's most of you, we are mostly a grant-funded climate policy and energy law organization housed in the Environmental, Natural Resources, and Energy Law program. Did I share the wrong slide? Am I sharing the right?
Oh, I think so. We can see, I think just your cover slide. Maybe it didn't advance yet.
Yes, that's all I've got here.
Okay.
I want to make sure it doesn't look like, did that get to the agenda?
Yes.
Okay, perfect. Thank you. Yeah, so we're mostly a grant-funded climate policy and energy law organization housed in the Environmental, Natural Resources, and Energy Law program at Lewis and Clark Law School in Portland, Oregon. So our mission is to develop smart and comprehensive strategies to support a swift and equitable transition to a carbon-free energy grid. And it may be useful to know that I started my legal career by serving as the city attorney with partners in my former law firm for a number of cities in Oregon. And so for those staff and counselors on the meeting, I just want to say your job is a hard one. You are managing a multitude of demands and emergencies, and it's easy to delay tackling climate issues. Decisions like the Ninth Circuit's on Berkeley's ordinance can make it difficult to move climate action to the top of your city's priorities. But as you know best, local governments are the places where good ideas are born and then spread. And Berkeley is the perfect example of that phenomenon. And I just also want to add that I occasionally have the opportunity to work with youth who often face opposition at every turn and who are impatient with the pace of action, as only the youth are. And when they meet with officials who take them seriously and who push for change, it restores a little bit of faith in the adults around them. So as you multitask while watching this webinar, finishing up tasks at the end of your workday or preparing your family's dinner, depending on your time zone, I hope you'll take away a nugget from this hour we have together that may make your institution the next Berkeley. So let's get started. Here's where we're headed today. We'll start with authority and then move to barriers and then remaining pathways. So one note, as Anne mentioned, I work in Oregon, so much of my knowledge and experience relies on what is allowed or not allowed in this state. I will, however, flag where differences may exist. And you'll see I use the phrase layer cake here on this slide. We all know our governments interact with each other in much more of a marble cake kind of way, but I find it helpful to consider the different levels of government in evaluating avenues for action. So I'll touch on how local governments can bind themselves, how state policies, such as building codes, may impact policy, and how, of course, what you're all here for, federal law preempts some local regulation of natural gas. And then I'll discuss what authority remains. So please don't go to sleep on me. These are important principles. Maybe only the legal policy wonks in the room will appreciate this, but I think it is helpful to sort of set the stage. So general principles of local authority. So we think of the US Constitution. That provides power to the federal government and to the state governments. Everything flows from that. But the Constitution does not mention local government powers. Instead, local authority comes from the state. So Oregon's constitution allows city voters to confer authority on their city governments by enacting a home rule charter, which acts as the city's constitution. Most charters in Oregon, at least, give cities the maximum authority allowable by law, rather than enumerating specific powers. As a result, cities are authorized to protect public health, safety, morals, and welfare, to license, and to tax. So this is capacious authority. Since the charter typically authorizes the action, the only remaining question is whether the law is preempted by state or federal law. Preempted is kind of a term of art, and it means whether the state or federal law takes precedence over the local law. But some of you may be located in places without home rule authority. You may be in a location that follows Dillon's rule. And so I'll just quote the Sabin Center's excellent publication on local authority called Cities Climate Law, a Legal Framework for Local Action in the US. Dillon's rule is the doctrine that a unit of local government has no more power or authority than the authority the state has expressly granted to it, along with any implied powers necessary to carry out a grant of authority from the state government. And I'm going to put that publication in chat so you can access it for more information, because it actually is really excellent. It may be one that you all have heard about. It was published in 2021, but you may have forgotten about it. And it's a good one to have easily at hand. So we start with preemption, how it's analyzed under federal law. So again, preemption is the notion that state law outweighs local law and federal law outweighs state and local law. And the supremacy clause of the US Constitution directs that federal law is positioned over state law. And because a city is a creature of the state, federal law also trumps local law. So accordingly, when a local law conflicts with existing federal law, the federal law can preempt or take precedence over the local law. Remember this slide when we begin discussing the Berkeley decision, and you can see the various sort of flavors of preemption under federal law here and their descriptions. So it really does depend what kind of law we're discussing here, we're analyzing. But of course, you also have to evaluate preemption under state law. And so this slide describes the two options reflected in Oregon law, and they're a little bit different from the federal ones that you saw. So in Oregon, to preempt a local action, the state law must clearly and unambiguously preempt the local government from acting, or it must be impossible for the local and state law to operate at the same time. So you can see that's pretty open authority for the local government to act. Important to then connect with folks in your state about what preemption looks like. Notably in Oregon, there is no occupy the field preemption. Other states do have something called field preemption. And again, just as in federal law, field preemption happens when the state legislature indicates it intends to occupy the entire subject area. And it can do that either expressly or by implication. Before I jump into more detailed barriers and options, I provide here a map of the gas delivery system because it's helpful to get a picture of where local authority applies. So to provide service to customers, gas utilities need to install and maintain infrastructure on or beneath public rights-of-way. And you'll hear me use that term a couple of times throughout the webinar. And what I mean by that is public streets and sidewalks to connect to the gas meter outside the building. And you'll hear me talk about the gas meter outside the building when we talk about the Ninth Circuit's decision. So I'm going to move in reverse order of the layer cake now, from local authority up to federal authority. You'll remember that the first layer I mentioned in my agenda, I noted franchise agreements or licensing ordinances. You can see franchise agreements, and I know every state does it different. So again, this is one of those things that you'll want to check in with your local government about. Franchise agreements are a contract with the gas utility. Licensing ordinances or right-of-way ordinances are something that local governments here in Oregon are starting to starting to make use of, and they apply to all of the utilities, not just the gas utilities. And they're an alternative. But either a franchise agreement or a right-of-way ordinance or something that your local government has may operate to bind a city from adopting a policy restricting natural gas. So local governments should review any of those agreements that might bind them and determine whether any terms preclude natural gas restrictions. One thing to note is that franchise agreements often have automatic renewal provisions in them. And so if you think that your local government has a franchise agreement, you'll want to take a look at when that renewal comes up and act promptly in advance of that termination so it doesn't automatically renew. So then we move to the middle layer. So I mentioned here building codes. The most common method used by local governments around the nation is to use building codes to restrict gas. But as I mentioned, any local law seeking to promote building electrification will need to avoid regulating in an area that is already controlled by state or federal law. So, for example, some states have enacted legislation prohibiting restrictions on natural gas. In a state with an occupy the field preemption, like I understand Massachusetts is, state public utility laws might preempt local restrictions on gas if it appears that the state law was intended to occupy the entire field of utility regulation. And some local governments have building code authority. When we're talking about building codes, at least here in Oregon, our law expressly preempts local governments from adopting ordinances that impose different requirements than the state building codes do. So lesson here is check your state system. Okay, now we move to sort of the prime event here, right? EPCA. So EPCA stands for the Energy Policy and Conservation Act. It's a federal law that preempts, it's a federal law. And it has language in it that expressly preempts any state or local regulation concerning the energy efficiency, energy use, or water use of a covered product. For purposes of the Berkeley decision, concerning energy use and covered products are the important words here. Covered products include equipment like furnaces, HVAC systems, gas ranges, and water heaters, all the appliances and equipment that we think of in our homes. There is a building code exception to EPCA preemption. That exception allows energy efficiency or energy use standards for EPCA covered appliances, so long as the building code complies with 7 explicit statutory criteria. We'll touch on that a bit later. Okay, so as you know, in April, the Ninth Circuit issued a ruling finding that Berkeley's prohibition on natural gas piping in new buildings was preempted by EPCA. So I note here, Berkeley adopted this restriction as a health and safety measure on fuel gas piping in newly constructed buildings from the meter. I note that because the Ninth Circuit, particularly in the amended opinion, interpreted the ordinance as a building code. So I just flag that for you. They make no explanation. They give no explanation for why that is, but I flag that for you. So what did the court say? The Ninth Circuit held that EPCA preempts state and local standards that interfere with the end user's ability to use installed covered products at their intended final destinations. And you can see here in red, the amended opinion adds the words like restaurants. So this interpretation was broader than the Department of Energy and stakeholders expected. Berkeley filed a petition for en banc review over the summer. In the meantime, advocates and stakeholders and experts got their heads together. We'd already been thinking of it prior to the Berkeley opinion. What are the pathways? What's the authority, the legal authority for local governments to take action on restricting gas? But it was a little bit of a pause, I would say, in government action last year, as everyone held their breath waiting for the Ninth Circuit's decision on the en banc request. But on January 2nd of this year, we welcomed 2024, unfortunately, with an amended opinion from the Ninth Circuit. That amended opinion again concludes that EPCA preempts Berkeley's ordinance. Lesson from the case: no local government may prohibit natural gas piping within new buildings from the point of delivery at the gas meter. You can see some of the quotes from the case here. Again, language that was added to the amended opinion is in red, and then there's one where it's in brackets in red, where they eliminated that language. It's hard to read too much into some of the amendments. Sometimes they're just clarifying language, correcting citations. Sometimes I think there is more meaning behind some of the changes. So what remains? Local governments may manage how, when, and where utilities use public rights of way. They have authority to act to protect public health and safety, and they may use existing processes to restrict natural gas use in their jurisdictions, so long as they keep their local authority in mind and consider existing state and federal barriers. You'll see a few of those options listed here, and I'm going to go into each one of them, as well as referring back to some of the language in the Berkeley decision. This slide reflects what could be an easy way to stop digging the hole. It suggests an ordinance that prohibits new fossil fuel infrastructure, or something along these lines, defined as natural gas piping, fuel oil piping, or other fossil fuel piping or conveyance system in a public right-of-way. Again, remember, public rights-of-way being the city streets, sidewalks, which, again, depending on where you are, cities typically have authority over. If you are in a place that recognizes home rule, as I said, local governments typically possess control over their rights of way. In Oregon, cities actually have explicit statutory authority to identify the terms and conditions of the public utilities' use of public property. And in fact, the statute explicitly says that cities may exclude or eject a utility from public property. So there might be statutory language that's helpful as well. You might ask, what about the Berkeley decision? If you're precluding the expansion of the gas system to the home where a covered appliance is used, won't that preclude the use of that energy by that covered appliance? Aren't you impacting the ability to use a covered appliance? I'll just say that in its opinion, the Ninth Circuit recognizes local authority over the distribution system. I have reflected here the language that was added to the opinion in January, and you can see it's quite explicit. There's also other sections, other statements throughout the opinion recognizing local government control over the distribution system. So, for example, this is a little bit of a legal nuance, but the city in Berkeley argued, hey, court, your interpretation means that we have that it is in conflict with the Natural Gas Act, another federal law. That Natural Gas Act gives us the authority over the distribution system, and your interpretation will impliedly repeal that act. And the court added language in the amended opinion that said, we see no implied repeal problem because the ordinance doesn't prevent a utility's distribution of natural gas to the meter at new buildings. Rather, it prevents the use of covered appliances by banning piping within the building from a meter to an appliance. When gas arrives at a meter, it has been delivered to the user. Rather than interfering with distribution of natural gas, the ordinance prevents a building occupant from using available gas to run a covered appliance. Okay, so now we move on to emissions ordinances. So in addition to control over the distribution system and the Natural Gas Act carve out for local government authority over distribution systems, the Federal Clean Air Act gives states and local governments a role in enacting emission standards for sources of air pollution. This includes the authority to enact emission standards for fossil fuel appliances like furnaces and water heaters. Depending on a local government's authority to regulate air pollution, a building or appliance emission standard might be an option. New York City's building emission standard is a good model to use. That ordinance prohibits newly constructed buildings from, quote, combusting any substance that emits 25 kilograms or more of carbon dioxide per million BTUs of energy. Air quality management districts in California and in states like Texas and Utah prohibit the sale or installation of appliances and equipment that emit high levels of nitrogen oxides. Adoption of an appliance standard, either in new construction, if you wanted to limit it and test it out, or for any appliance, which would include existing buildings, sold or installed in the city, is a safe option. Okay, now we move to EPCA compliant building codes. So remember I mentioned at the beginning that EPCA has a carve out 7 criteria that are listed in EPCA. If a building code complies with those criteria, the local government or the state will not be in violation of EPCA. You don't want me to read these aloud. I'm going to put the link in the chat. If you are an energy efficiency guru, you will appreciate these and understand them. But believe me, you don't want me to read them aloud. In effect, we know what an EPCA compliant building code should look like. Washington State's approach, for example, is a good place to look. That state code requires builders to meet the same energy performance of buildings heated with electric heat pumps, but the choice of which measures to implement remains up to the developer. And that the remaining options are those that we have somewhat explored. Building performance standards are another option that are available. Seattle just adopted building performance standards, and they've actually been in use in places around the country, including in DC and Denver and other places. A pollution fee is another possibility. And then voluntary incentives are always acceptable. Again, all of these things depend on your local authority to act and any state barriers. I just will note that I know a few of the folks who are going to be doing the next webinar on this topic are on the call today, and I'll pitch it again. The Public Health Law Center, RMI, and Institute for Market Transformation will be doing a webinar with 3 instead of 1 experts, and theirs is entitled "What's Next After Berkeley? How to Avoid EPCA Preemption with Building Decarb Policies." So they'll go more in depth into what EPCA does and does not preempt, and in particular, I understand building performance standards will be a main point of discussion. And then I'll just reiterate Anne's point at the beginning about connecting with experts when each city is considering the decarbonization pathway that's right for it. We know that equity concerns are different in each city, and as well as policy interests, and of course the legal landscape is different in each state. So that's what I have. I am going to go ahead and put some of those things that I indicated in the chat. I'll put the Sabin Center's local guide, as well as the 7 factors for EPCA building code compliance. And then I'll also put in the chat our Oregon's regulating natural gas. We published that, unfortunately, right before the April 9th Circuit decision, but many of the descriptions about local authority remain useful, as well as perhaps some ideas that might spur action in your city.
Thank you so much, Kara. Amazing. There's some appreciations coming through in the chat.
Yeah, I hope I didn't make anyone fall asleep.
No way, no way.
I want to address Gary's question because it's one he emailed me, and I think it's a good one. So the question there is, the 9th Circuit's amended ruling states that EPCA does not affect local government regulation of natural gas distribution. You're absolutely right, Gary. Wouldn't the ruling then allow local governments to simply ban the connection of new buildings? Oh, I lost it. Did you say it answered it? Okay. Ban the connection of new buildings to the natural gas distribution system. Okay. So I think the important thing here is from which place you're coming. So if you are talking about no hookup from building to meter, you are probably going to run awry of the Ninth Circuit's decision. If, however, you are talking about expansion of the piping in the right-of-way, that's different. So the question is, and this is unanswered, we don't really know how much piping, a brand new subdivision, for example, that doesn't have any piping. I think I feel fairly comfortable, you're never 100%, but I feel fairly comfortable that a local government, depending again on where you are, has authority to prohibit expansion of the gas system. But banning it at the building is going to be problematic. So I hope that answered your question, Gary. It's all in how you approach the regulation. Let's see. If an ordinance applies only to new construction, then a gas using appliance can't be in use, correct? Well, it depends on what your policy is. If an ordinance applies only to new construction, I think the lesson from Berkeley is a city cannot preclude the use of energy if it's available. So I don't know if you have, Jeff, if you have a little bit more you want to give me there, happy to have a little bit of back and forth if I didn't answer your question. Kate's question, new emission standards look like a good option. Wouldn't it be applicable to all appliance installations? So replacements in existing buildings as well as new buildings could be covered. Absolutely, Kate. So that's how the Bay Area Air Quality Management District, the South Coast Air Quality Management District, and other Texas and Utah each have these limitations on nitrogen oxides. It is an appliance limitation which impacts the sale or installation of these appliances that exceed the NOx limit. So that would impact new and any existing appliances when they burn out. You'd have to replace it with the low NOx. Here in Oregon, I think cities are a little bit. There is also an option to approach this a little bit slower and just impact the appliances or equipment that are installed in new construction as a way to sort of test. But absolutely best to get to all applicable appliance installations if that's possible. All right, Jeff, if it's not piped to the building, then is it available? Yeah, great question. Possibly. I think it really does depend on, and I'm sorry, I know that's the worst to hear from a lawyer. It depends. But you just want to be careful about how far away that gas, I mean, we just don't know. I mean, like I said, it's very clear where there's no gas anywhere near that subdivision. And then the question is, if there's a main and you want to just connect from the main to the private property, is that little piece, is that also something that a local government could preclude? The answer, I think, under the Ninth Circuit decision is yes. But I think yet to be seen how far the reasoning goes. I saw some questions in the chat too, I think. There was a question about the 7 standards. Yeah, let me go ahead and put those in. The 7 standards are the EPCA, the Energy Policy Conservation Act, which has a specific call out permission for building codes, so long as they comply with those 7 statutory criteria. So the federal government identified the kinds of building codes that the Congress felt were acceptable. And so I will put that here in chat. And you're right, you do not want me to read them out loud.
Well,
Kara, we have a few questions that came in.
Yeah.
If I could just read them off to you.
Absolutely.
So are there any examples of places successfully denying the right of way to gas companies?
So not yet. And I think that's partly because cities, I mean, I'm speculating here, but cities, it is very natural to address this issue in building codes. And there what has been, cities with building code authority. And that's the path that, most of the local governments we saw acting took. I think the other question is how built out the city is. If it already has gas available, it is harder, right, to preclude gas piping in the right of way because it's already there. So yeah, we haven't yet seen, I don't know of any, I will say, local governments that have used right of way authority to preclude expansion of the gas system. Franchise agreements are also going to be a barrier. And, if a local government, even 5 years ago, this is a relatively new discussion that we're having about methane and how to regulate it and it being good for climate action. So cities that were on the front edge, right, like Berkeley, were fully aware, and I think others were sort of following behind. I know, Portland renegotiated its franchise agreement and it is good until 2029. So, even a city like Portland that's relatively climate conscious wasn't thinking about franchise agreements. So that could be another reason why right-of-way authority hasn't been used.
Thanks for that. One other question we had is there a sample city ordinance? Is there sample city ordinance language for an efficiency standard? We know there was what Washington State did. Is there a city that has done that already, or is there a sample of something like that?
That's right. I will beg anyone on the call who has this expertise. It's something that I have been wanting to do, which is an EPCA compliant building code that's relatively simple for a small city to adopt. We only have Washington that I know of. Yeah, so maybe others know about other options, or maybe there's something in the works. But that's, working on it. Yay, RMI is working on it. Great. Thanks, Johnny. Work faster.
Fantastic. And it looks like we got another one from Madeline Salzman. Is there an accepted definition for what counts as new in the context of distribution equipment? Is it new pipe footage, new connections from public system to buildings, or piping replacement from new pieces?
Great idea. So I just came up with that ordinance language just in trying to help cities see how easy it could be to just stop digging the hole. So it will depend on how the city wants to define it. That would be up to the city, city discretion. Thinking also about any kind of public utility, public service commission type restrictions that there might be.
Great. This is a really great conversation. I am appreciating the questions that are coming in, and Nathan for bringing in some that had come in before. Just a quick note while people probably put some more questions in the Q&A. We, again, don't want this conversation to stop today. There's obviously lots that is still going on in this area. And so it may have already been shared in the chat. We want to help you stay connected to the Green Energy Institute. We want to help you stay connected to Safe Cities. There are different ways to do that. We want you to also join the webinar that RMI and partners are doing next week. And then also Councilmember Kate Harrison, who was the sponsor of the ordinance in Berkeley, released a great statement on the Friday after, so that was like, January 5th, and we're going to share that as well. And some no revelation yet on what Berkeley may or may not do in terms of appealing the decision, but great notes on what one policy inspired, and how this movement is really unstoppable despite this challenge that we are addressing right now.
Yeah, and I see another question in chat that's a good one from Mark about discussing how IRA incentives are in fact affecting this issue. So I would say, I mean, one of the things, don't forget about the IRA incentives, right? Like that's going to be the number one way we're going to move folks away. Regulation is important, right? And I think we've seen that at least here in Oregon, communities that aren't trying to tackle this, that are relying on voluntary action, are falling behind emissions goals, but work in tandem. So yes, so no question, the importance of educating, especially rural communities, about the options. I think too about communities that are not operating under an investor-owned utility structure, whose, you know, sort of if it's a publicly owned utility, may not be as keyed in. Just really making sure that folks maybe outside the normal structures are getting the information that they need about those incentives.
Great. Looks like we got two more questions. I think they're both for places outside of the Ninth Circuit, but I know there's reverberations from this decision. The first one is regarding Massachusetts. They've approved 10 cities to ban gas hookups in new construction. Is the approach they're using at risk following this Berkeley ruling?
So I say no. I mean, yes, of course, right? There's risk. There's always risk. But I would point you to Judge Friedland's dissent, which I think very thoroughly and thoughtfully, and not just because I agree with her, articulates the meaning of the provisions that we were talking about during this webinar in a way that recognizes the technical nature of the statute and really chides the panel for neglecting to recognize the technical nature of the statute and sort of using more common sense definitions or interpretations of the terms. This is the EPCA, the Energy, you know, the name alone, right? Energy Policy Conservation Act. It's a very technical act, and I think that I expect Judge Friedland, and she's indicated as much in her dissent, intended her dissent to provide an alternative point of view that might be helpful. So I think, you know, it could go either way, of course. It depends on who your panel is, but that dissent is really helpful in providing an alternative discussion of what the statute meant to get at.
Great. Thanks for that. And this one is regarding New York and New York City. I think it's they're mentioning in the question, it's from Kirsten, so I apologize if I'm misunderstanding this, Kirsten, but it's saying the case against New York State that's being sued for their policy.
Yep.
Will New York City's ordinance stand even if the state loses their case?
Yes, New York City. I mean, the one I was discussing is an emissions, a building emissions standard adopted under the Clean Air Act. So my understanding is that it would stand. It could separately be subject to litigation, I suppose, but we haven't seen that yet.
Great. Thank you. And then I think there's one more, and we may have touched on this already. This is from Gary Barber from 350 Contra Costa. He's asking, the ruling appears to disallow not being able to use natural gas when the piping is connected to the meter. But where does the ruling state that localities cannot ban the connection of the regional gas system to meters?
It doesn't. Yeah,
Okay.
it doesn't. Nope. And so I think that's the trick is the thing about case law, right, is that the analysis applies to the parties in the case and the facts of the case. And so we have real clarity on what is allowed under EPCA. We have real clarity that Berkeley's ordinance is not allowed under EPCA. We don't have a whole lot of clarity on how far that reasoning goes. So I think that's it. It's just a cautious approach. And I'd welcome any other folks who may have an opinion on that. But I think it is just a matter of evaluating each city's circumstance, and then, you know, carefully considering the risk averseness or not of the city, and its willingness to take a chance. It's the reasoning of the opinion that I think gives people pause.
Great. And then it seems like there's some interest in the chat about specifically on reach codes and how this all factors in, you know, the difference between the reach codes and maybe what Berkeley did. You know, and specifically I see that looks like Johnny shared a resource around local reach codes, but yeah, there's just maybe you could speak a little bit more to the differences between the reach codes and what's still possible through that venue.
Yeah. So again, it comes back to what EPCA does and does not allow, right? And EPCA does not allow a building code that precludes energy use in a building when a covered appliance is there and ready to use it. And if a building code complies with the 7 factors that are specifically set out by Congress in the federal statute, you're golden. And so I think what Johnny said here is that there are local reach codes in California that use the 7-factor test. So they've done the hard work, right? They checked all the boxes on the EPCA 7-factor test. You don't have to read them, and they're ready to adopt.
That's great. I don't know if there are any additional questions that we may have missed. And or anyone else, if you guys feel free to put stuff into the Q&A or the chat if there's other things that haven't been covered. Give folks a second here.
Yeah, if there's nothing in the Q&A tab that is.
I think there was one question earlier about the relevancy of this to Canada, and I would believe that's going to be let's ask the expert.
Not an expert on Canadian law, I'm afraid. Thought about that when Anne flagged that there'd be somebody from Canada, and thought, oh my goodness, I just don't know what your provincial government would allow or not.
I'm curious if I can ask maybe Anne and Kara, from your non-legal assessment, how are you feeling about this moment? Are you feeling hopeful, optimistic, defeated, a little mixture of both?
I was disappointed. I was not surprised. I will say that, as I mentioned, GEI at least has been working with cities on alternatives since before the Berkeley decision. And that's partly because not all cities, we can't do building codes here in Oregon unless we get approval from our building code division. So that was kind of off the table. And several cities have franchise agreements. And so we knew that a Berkeley style ban would be problematic. So we were already thinking about alternatives. So move onward and upward. One thing I will say is I would really like local governments to think about layering options, right? Like, what a show to send to the fossil fuel industry that they adopt all 3, right? They do a pollution tax, they ban new gas, not fossil fuel piping in the distribution system, and they adopt even if it's just a NOx appliance limit on hot water heaters and furnaces, all sort of 3 relatively safe approaches that get at different problems. And I think, did I say a pollution tax? Because, then you have a source of revenue to assist people in transitioning off of gas.
Yeah, we've been describing it as they think they beheaded the dragon and get knocking down Berkeley, but little they know our movement's a hydra. We're gonna grow all these different heads and come at them through all these different mechanisms, right?
We can't give up. We can't give up. It's too important.
I appreciate that hopeful note, and I'm curious, Anne, or I don't know if Cheryl's still here too, because that would be interesting to hear how she's feeling.
I have some things to say, and if Cheryl is here and wants to jump in, I want to let you go first.
I'm here. Yeah, I think, thank you, Kara. That was such an excellent presentation. Made me understand everything a lot more clear. I don't know. I'm hopeful some things will change. We'll see what happens, but I'm not in it, so I'm not as involved, but I'm paying attention. So let's keep hope alive because there's so much to hope and pray for these days. Thank you.
Thank you, Cheryl. I feel pretty hopeful. I'm usually a pretty optimistic person, perhaps to the point of being naive sometimes, but per what Kara was talking about the options and what Nathan said about the Hydra, it is my dear hope that the way that the gas industry is fighting this movement is already ending up spurring creativity, like the kind that Kara and others have shown in developing policies that they will not be able to stop, and that will be for both new construction and existing buildings. And so this is definitely a challenging moment, and we have a lot of work to do because we want to help all of the communities who've already passed things shore it up or replace it. We want to help new people, new communities do things that are a good fit. So it's definitely like a time we're rolling up our sleeves massively, but I'm hoping that in the end, this is the place where the tide actually started to turn, to have just electrifying everything, new construction, existing buildings, keeping in mind those equity concerns which Cheryl raised, all of it. That's my dear hope, and I see signs that it can definitely happen. And just having so many people gathered here today working on this together, exploring this, is one of those really hopeful signs for me. Well, and we have just a couple minutes. I want to let Michelle take us out, unless there was any last, do we have any last questions or anything? Oh, there's a hopeful note from Jeff in the Q&A about about Chicago. I want to thank you all so much for being here. I'm going to turn it over again to Michelle to take us out. We will get you links and recordings and slides and all those good things. And huge thanks to Cheryl and to Kara, and to everybody, to Michelle and Nathan, everybody on our Safe Cities team, Green Energy Institute, and everybody for joining today.
I'll share my little bits of reflections too, is that I think what makes me most exciting was to see what was happening in the chat for a little bit, where somebody was like, does anybody know of a place here? And then somebody else was chiming in and they're like, no, I'll follow up. Here's my email address. I think it's precisely those sorts of connections and creativity that are going to get us. Because at the end of the day, like the law and the legal restrictions, it's a game of chess. And so it's going to continue to evolve, and we're going to also continue to evolve and adapt and have Zoom webinars where people are chatting it up and figuring out new creative ways. If you like what you saw here today and you want to continue to stay involved with us, we would love to have you. As I mentioned at the top of the call, we welcome folks who are outside of City Hall. If you're a group with a 350 or a Sunrise group or any sort of climate group and you want to continue your involvement, we host spaces like this for you to kind of get those political chops and kind of analysis from inside. And if you are an elected official, if you're running for office, if you're a staffer, I can also connect you with Anne so you can join a community of like-minded folks who are also trying to pass these policies. But rest assured, everybody that is registered for this call will get a copy of the recording as well as the slides. But yeah, I just wanted to thank y'all for here. One final little plug is that we have these calls on a monthly basis, and in February on the 3rd Wednesday at 4 p.m., same time as now, we're going to be unveiling our transportation policy. So we also do some of this work around fossil fuels, specifically around the transportation sector, specifically around the growing world of e-commerce and all the quandary of ways of how we regulate that, because it's a new industry that we don't quite know how to respond to yet. So if you're interested in transit, or you know somebody who's interested in transit related work, please invite them to the call. But that is all. No final last minute burning questions. You are probably already on our list, sir, but I will double check. All right, y'all. Thank you so much for being here today.